Welcome back to the show. I'm your host, Ankur Patel, and today I'm joined by Michael Heller, Associate Attorney at Messick Lauer Smith, a Philadelphia firm whose practice is built around advising credit unions and CUSOs. Michael runs the vendor side at the firm, contracts, due diligence, and the messy middle of getting tech deals done without blowing up the regulatory picture. Today, we aim to cover what's actually gone wrong in credit union and vendor AI deals, why risk management is the framework everything else hangs on, and what it looks like when an institution truly gets this right. Michael, welcome to the show.
Thank you so much for having me, Ankur. I'm looking forward to having this conversation.
We usually don't get too many lawyers on the show, Michael. So I'm curious, how did you end up in this particular seat, and when do credit unions bring you to the table?
So I don't think that that's any fault to yours, Ankur, as to why you don't have too many lawyers, by the way. That makes total sense. Sometimes we get a little too much into the weeds. But some of my background is I actually graduated law school in 2010, right? Like in the aftermath of the Great Recession. So at that time, you're kind of looking for anything you get your hands on from like a job perspective. And I live in Philadelphia, so I ended up working on a contract basis at Comcast. They're headquartered here. And what they needed help on at that time was their new home security product. So what's interesting about that is we did a lot and had a lot of conversations with local regulators about the concept of wireless home security systems, because everything was hardwired into, whether it's a building or a home at that time. And so where I kind of took that into where I am now at Messick Lauer Smith is to really focus on that compliance aspect from a regulatory standpoint. Obviously, finance is much more expansive, than what I had been doing at Comcast. And for a variety of reasons at our firm while I was new, my path deviated a bit. And where my focus really kind of seemed to concentrate on was really being our vendor management expert. So I deal a lot on the technology side, the service side from all types of services, because our firm primarily represents credit union service organizations, and that can be really any type of product or service. But on the tech side, we have seen over the past 5 to 10 years now a lot of fintechs entering space into this space and partnering with credit unions, and that's pretty much where I get looped in. From a contract side, from a vendor management best practices side, that's really where I enter from a deal standpoint.
Could you help articulate, at least for our audience, credit unions, CUSOs, right, the service organizations, how they fit in? And then which one you end up serving in which capacity, especially because I think what you're saying is that there are a lot more fintech deals that happen, right? We could talk about what sorts of deals, but curious sort of how does all of this connect to each other?
Yeah, sure. So credit unions, so basically, right, that's a financial institution, and we do represent them in that capacity. But credit unions are only authorized from a legal standpoint to offer certain types of products and services. And so what the NCUA has done is they have carved out a certain regulatory scheme that allows credit unions to invest or loan to credit union service organizations. So those are CUSOs. And so what our firm really specializes in is the formation of these CUSOs. So we do represent both, actually, credit unions and CUSOs. So I think that puts us uniquely positioned in the space to have an understanding as to what each side thinks about when they're thinking of these types of deals.
When fintechs come to the table, is that just a vendor relationship that you get brought in to negotiate? Is it more than that? So potential M&A activity, or other types of deals? Just curious the nature of the deals that you get brought into.
Yeah, sure. So it can be all the above there, I would say. But I think the primary focus is really on the servicing side. At least for me. We do have other members of our firm that do focus on M&A activity, but then again, also primarily focus on the formation aspect and finding the right partners between fintechs as well as credit unions. We have directly represented fintechs. on our side as they're forming CUSOs. And we've also helped them partner with credit unions. But because of conflict rules, obviously, we don't represent necessarily both sides of the deal. So to the extent that we do represent, a fintech CUSO, and we also have representation on the credit union side, usually we can't go through those agreements for both sides. It's primarily through probably the fintech at that point, because we would probably work on that specific service agreement.
It's very helpful that you've seen both sides of the deal, right? So you've sat on both sides of the table, you understand what's at stake and where things work and where things don't. So I'm curious, when a credit union and a tech vendor sit down to do a deal, where do you actually see things go wrong?
So I would say, I think at the outset, right? Like to the extent you never see a deal come to fruition, I really think, you can kind of go back and forth as to how the contract negotiations go themselves. But I really think each party might have mismatched expectations or incentives, to enter the deal. And really what that boils down to is a lack of a shared vision between them, right? Now on the credit union side, I think that can come in the form of, real lack of understanding of the fintech's business model, how their product or service works, how that fintech might operate within the context and frame of their own industry. And ultimately, a fintech might have different goals from the credit union. It might have a different culture, and it might have different experience in offering financial products and services. I think on the fintech side, you can really hold up a mirror, right? And make much of the same argument. I think the tweak there, though, is that I think what I've seen with fintechs is there's a lack of understanding about the regulatory environment that they're really stepping into, and what expectations, even though they might have an understanding, there might be an unrealistic expectations as to what credit unions are expected to do from a regulatory perspective. So you usually see that with regards to, how member information is protected, understanding the security posture, how that might extend to fourth parties, that the fintech might rely on. And I think too that kind of similar on the credit union side, goals seem to be misaligned. And so that usually leads to deals that don't go through.
It is interesting how, in some ways, the fintechs and the CUs have different world views, right, in terms of how they operate. The credit unions, of course, very regulated space. In many cases, they've been around for decades. And like all financial institutions, they value themselves on stability and being reliable and kind of not having too much of a bit of break things to move fast type of mentality. And the fintechs, generally speaking, they're bringing in the latest and greatest technology, and they in some ways have a mandate to be a little bit more disruptive, because that's how they actually stand apart. And so it makes sense that there would be natural friction, right? As some maybe they don't see eye to eye on a lot of these things, but I think closing the regulatory gap. And so the CUs benefit from the speed and innovation that fintechs offer, but fintechs understand the very regulated environment credit unions live in, including all the brand risk that they carry of getting something wrong. And it seems like in some ways you're kind of basically the party in between that tries to help bridge the gaps when they occur. But I'm curious, obviously going in, both parties generally want the best, right? There's a reason why they're sitting around the table. But when things start to go wrong, is that clear from the very early days and meetings, or do things sometimes start off really well, almost like this honeymoon phase, but then perhaps a year down the line things go sideways? So I'm curious, when do you typically see that something that you thought would work isn't quite working out the way it should have, perhaps?
Yeah, I think that those are really good observations, Ankur, at the outset. And, how you kind of positioned our role, kind of like filling gaps, maybe in understanding between the parties, I think is accurate. Now, I fully agree that in a lot of these instances, there is this honeymoon period, right? And, you don't want to be the person in the room, but unfortunately somebody has to be that person in the room that points out, hey, this looks like a great marriage, but what about the divorce, right? And how do things get allocated? If things, as of right now, they look, fine and dandy. But, a year or two down the line, we might be seeing some real issues. So to answer your question, I really do think that some of the seeds of discontent can really be sown at the early stages of any sort of negotiation or what agreement is ultimately executed. And I think where I happen to see that the most, once you've kind of have entered into this agreement, the issue really revolves around ambiguity, right? And kind of what parties' expectations are and how one party might interpret what they were responsible for versus what the other party is ultimately promising to deliver. And I think from my perspective and what I tried to help with when speaking to clients on both sides of the aisle here, right, is I really do try to recommend as much clarity as possible. So that means, clearly allocating party responsibilities, identifying, the necessary operational controls, having measurable milestones, and then ultimately, how, if there are issues that can arise, how does that escalation happen, right? Who needs to be involved? What's the timeline on that? Because what I've noticed in contracts, because as I'm sure you've dealt with yourself too, right, is sometimes when it's a little more difficult to negotiate, I see issues that, really create drag, like in the process of negotiation and then ultimately execution. And it really is this concept of interpretation, right? Like when the intent of the parties is ambiguous, usually one party just kind of steps in to fill that gap. And that can ultimately lead to issues down the line. I think that leads to ambiguity. I think that could lead to delays in providing service deliverables. I think that could lead to breach ultimately. And on the customer side, that could be, leading issues with, risk and compliance issues, ultimately legal risk. So usually ambiguity, I think, creates cost, for both parties, not even the one that might be necessarily aggrieved the most.
And I think it's particularly difficult now with agentic AI startups and such, because in some ways, I think the companies are cropping up now, they aren't just delivering traditional software, right? And that would be easier. Like you get what you get. It is what it is, right? Like everyone gets the same copy more or less, and they can configure it and set it up. But the lines between like pure software companies and services is in some ways that line is fading, in the sense that a lot of software companies are built in the AI world today. They are performing work that services companies would traditionally do. So I'll give you an example where you kind of go into lending and help support loan officers and underwriters, and you're kind of taking on some of the work that they would normally do, and it's highly variable work. It's very configured to that one credit union. And then what happens is you start discussing things like SLAs, right? What happens if certain SLA isn't met? Or you might have conversations around what the cost will be per application that comes through. You've negotiated maybe an average cost or a max cost, like a ceiling, and then it becomes really hard. Where it's like, what happens if the dynamic changes, where the credit union's business maybe shifts, and it forces the fintech here or the AI vendor here to go and have to basically modify the terms of engagement, or something changes on the technology side, vice versa, and it forces like a reevaluation of the relationship. And or it could be something simple as the credit union decides that, hey, it doesn't want to use an external vendor, it wants to bring things in house, right? Like how do you handle that sort of scenario? Or in an unfortunate outcome, it could be that the startup goes out of business or gets acquired, has a change event. What happens then, right? Like, how do you deal with that continuity risk? So it feels like the surface area of things that could go wrong is now materially more complex and more challenging than ever before. Are you seeing or starting to hear similar things from CUSOs and credit unions on your side, and then potentially even fintechs? or are they still maybe perhaps too early on in their journey right now to kind of think that deeply about all of the different ways that things could potentially go wrong?
No, I think that you highlighted very real issues that we see today. And how do you cover all these different scenarios at play, right? One of the ways that I really like to kind of highlight that, and this certainly depends on the products and services at hand, but I think in these scenarios, it has to be clear between the parties. Kind of, you referenced a few different events there. But to the extent that there's any material changes like in law that could have an impact, right, on the service provider, and that's very relevant, I would say, today. I think that anything that has a material impact on, the service offering itself, from a credit union customer standpoint, there have to be clear pathways, I think, for each party to exit the relationship to the extent that one of those material events actually happens. But I think, because that's kind of like the tip of the top, right, in order for them to get out. I think given how quickly things can change with some of the examples that you just used, I think having a robust change management process is also essential today, right? An opportunity for both parties to come back to the table and to reassess the relationship based on the fact that circumstances have changed, and I think given for what we're talking about today, right? When you're talking about AI service offerings, a lot can change between today and next year. A lot has changed between today and last year, right? So I think maximizing flexibility in this area, having that robust change management process, I think is really important and essential to continue the longevity of the deal.
I think a lot of people that are newer to this space, potentially maybe have not done enterprise software or haven't worked in regulated spaces like this, they underestimate just how much time is spent on this legal back and forth and making sure everything is kind of squared away. And it's not usually a one and done. You have to go multiple times. Things can be changed in years 2 and 3, right? Sometimes there are multi-year deals that you're working through. But there's a lot, like the indemnification, right? What can you really indemnify against versus not? What are the liability caps? What are the insurance requirements? What are the change event things that need to be considered in terms of clauses being in place, SLAs? Where does the data reside? What sort of compliance frameworks do you have? And then are there audit rights on either side to, particularly on the credit union side, rather to go and see what's happening with the software company, right? And so there are so many things that are involved that, the bigger the deals, more complex the deals, the more top down the deals, this could take months worth of work, right? And I think it's not for the faint of heart. So I suppose my question is I think at the end of the day though, the objective on the credit union side, and I would say on the software side, or the startup side or the fintech side is similar, is that they're trying to manage risk, right? They're obviously thinking about the opportunity, otherwise they wouldn't partner, right? They're thinking about what value they can create by working together, right? And so everyone kind of has that as the motivating factor. But then when it gets to the legal conversation, it's less about how much value we can create together. It's more about how do I manage risks that I face, right, working together. And so how do you kind of think about having a framework for both parties or either party, because you only sit on one side of the table any given deal, but how do you think about that risk framework to apply when you consider basically making this let's say a more painless process than it would be otherwise?
Right. Yeah. And I think that just goes back to, again, regardless as to what side you are, that you're providing legal services for at that point, or you're representing at that point. This is taking a step back from the actual specific deal itself and to really reflect on, again, what type of risk management processes and what the framework looks like at your own institution, because that really sets the roadmap as to your approach, again, regardless as to the product or service, but any sort of vendor relationship that you have. Your risk management framework should be something that you can lean on to engage any type of vendor, regardless as to what they're offering. So I think that's where you have to start, right? And then it's from that framework that you make, specific recommendations for any sort of given agreement. And then ultimately, if you don't follow your framework, I think it's important to notate those exceptions as well. because, especially when these deals are very critical, to operations at your institution, you will be asked about these these deals and kind of what your thought process was as you're making them. So as much record keeping in that regard, I think is also pretty essential.
What's your advice to credit unions that need to do this, of course, in many ways, multiple times over the course of the year, certainly over the course of a decade? They have to kind of go through the same framework, negotiating vendor by vendor, sometimes renegotiating with the vendor. What are your maybe tricks of the trade in terms of what should they value and prioritize versus like what not to sweat, over the details on?
Right. And of course, there's no one catch-all answer to that, right? As a lawyer, right? Like I can't. I feel like I'm legally obligated to say that. But I think if I were to boil it down, right? Because I think as we represent credit unions, and even to the fact that we represent fintechs, leverage and the ability to negotiate these agreements, it really does fluctuate, right? And typically, the parties that we represent don't necessarily have too much leverage, I'd say, like overall, right? So one of the things that I point back to, kind of like to reduce that checklist, to the extent that you're seeing these deals come across your desk very frequently, is first and foremost, I want to know how I can get out of, this agreement with relative minimal financial loss as possible, right? I want to make sure that I have an alternative available. I think you had referenced earlier, whether that's through another vendor or bringing it on internally. I think that those are the two big questions that you have to ask yourself at the outset, because if you always have the answer to those questions in mind, regardless as to how you negotiate, I think that you always have that you can rely upon. And then I think with regards to, I was just referencing leverage and like party responsibilities, I think this is where you really focus on milestones between the parties, right? And you really focus on that day-to-day process and the back and forth, because, what I had mentioned earlier is that where we typically see these deals go awry within a year or two is this misunderstanding between the parties as to who's responsible for what, right? So even though you might not be able to negotiate an agreement back and forth, the fact that you can rely on this milestone framework, that these expectations that you had set yourself between the parties is mutually agreed upon, right? So you might not be able to change indemnification. You might not be able to change limitation on liability, but you should be able to both kind of come together and coordinate, what the work processes look like. So that's where I would kind of put all of my eggs, if you have to go through these deals and a lot at a time in a short period of time. So exit strategy, and also, what the day-to-day looks like, and really focus on those two things.
Is the advice for the fintechs the same, or is it, do they have different things to value on their end?
I think it is the same. I think it could be through a different lens, of course. But I think, again, because we've also represented fintech clients dealing with other vendors, right? So I think that through that frame, it's exactly the same, especially if there's a absence of leverage there too. But from the credit union side too, in fintech and credit union deals, I think that is also important too. Typically, I think in those scenarios, the fintech has the ability to dictate the terms a little bit more. But I don't think that any deal, again, trying to take my both sides approach here. I think it's really important, for an understanding between fintechs and credit unions, the importance that the relationship really shouldn't be one-sided at the outset. And I think the ones that have the most success are the ones that realize where the risks really are and how they should be allocated between the parties. I think that's where you see the most success.
Yeah, ultimately, I think you have to set yourself up for a long-term partnership. And so you try to figure out what's really important to the other party. That's an easy give on your end. And I think that's where a lot of great deals could be made. But having a good framework of like, here are the things that I consider like P1, like really important priorities, versus here are like nice to haves, but I'm not really going to fight tooth and nail because it just doesn't matter at the end of the day. I think is really great, because then it makes the negotiation process a little bit easier. You have basically like a North Star approach to what you value versus not, right? And it's helpful. But the other thing that we constantly hear is that AI is so new that even the regulators are kind of writing the rules of how AI should be governed. So for example, like if you use AI in credit decisioning, right? What is the credit union responsible for if they're trusting a fintech or an AI firm startup, let's say, to go and support that, right? Does the credit union have liability, and if so, to what extent, and what liability, if any, does the startup have or the fintech has? And how do you kind of de-risk that, and then what insurance policies are appropriate given the nature and scale of the relationship? And so I'm curious, like, how do you handle these sorts of questions? Because it feels like the regulators themselves are somewhat figuring this out. But then, if the credit unions enter a deal that may make sense today, in the sense that it's basically compliant with the modern regulatory framework, but then in 2 years' time, the regulators kind of change things up, and then all of a sudden the deal isn't quite standing the test of time. It's pretty tricky, right? And I think we've definitely seen some financial institutions shy away from taking on any risk until they see their peers or they see regulators clarify some of the gray areas. But I'm curious how you're working through these questions with your clients.
Yeah, I think that that's a really good point. All of them really, but how you kind of ended at the latter there, and how I would address this with clients specifically is from the credit union side. It's always important to emphasize that although you may utilize a vendor to provide a certain product or service, you can't outsource the risk, right? The regulatory expectation is that, even if you use through extension, like a third party to offer that product or service, whether that's something that's internal for internal operations or something that's more member facing, you're still on the hook for that at the end of the day. So from a credit union standpoint, I would really lean on, what those internal risk management framework and what that looks like. Because and when a regulator comes in and asks a credit union, how'd this go wrong? Why did this go wrong? How did this breach happen? When did you get notice? They always focus on the credit union and when it received the adequate information. And then you could look back at the agreement. How come you didn't negotiate this? How come you didn't, even though it's like a regulatory requirement? So, the credit union can come back to the regulator all at once and to say, like, hey, but my vendor. The issue is that the expectation from the regulatory side is that, hey, credit union, you're in the position, to actually negotiate these things, and that you're in the position to ultimately, deal with any risks that are inherent in offering that certain product or service.
I want to just echo that. I think that's the right frame, especially because you have mature regulation for what a credit union does. And while we're all kind of waiting for the regulators to figure out how AI should be regulated, and it's unclear, right? But at the end of the day, if you think of it as just a tool that's enabling the financial institutions to do their work better, but the financial institutions, they are regulated, right? They have fiduciary responsibility. They have all these things. It's pretty clear cut there. And so if you're using this tool, it's AI, happens to be the modern version of AI, but it's still a tool. And I think the responsibility is still with people that then officially sign off on these things. And so you do need things like human in the loop checks and reviews. Hopefully it's not checking every little thing that the AI does, right? So you might do reviews towards the end of the process. But I think that final like rubber stamp that people apply, that is still regulated in the same way, right? I don't think we're in this world where the AI runs from start to finish, and then the AI decision or the AI model then has to face like regulatory scrutiny as did it make the right decision or not. I think the burden of proof and the burden of evidence and all of that is still on the financial institution. So I think that's the right frame today. I don't know if there's another way around it. So I tend to agree. I think that's like really astute advice. I mean, you're a lawyer, but I just think from a pure practitioner perspective, I think that's sort of how we would try to address it too. Is like we're gonna give you better tooling to go and do your work better, but at the end of the day, we still need human in the loop. It's still a requirement given how all of this works. It's a non-deterministic model as well, right? It's like it's and there are issues with it. Like AI is not perfect. We're not in this AGI world, so you still bear the full responsibility at the end of the day. but hopefully things we introduce, better picks and shovels that we offer, make your work a lot easier than it would have been, 3 years ago, let's say.
Yeah, and the one thing I would just add to that is it's definitely a space to pay a lot of attention to moving forward. We have seen states, starting to step in to this space from a regulatory standpoint. I know that California and New York come to mind with regards to how they look at frontier modeling. I would expect, that to continue, especially on the state side. What's also interesting to monitor there too is there has been this threat from the federal government, from an administration standpoint, with regards to an executive order as to whether or not, state laws will be preempted ultimately by federal regulation. But so to your point, we might see, I fully expect either way that space we'll see regulators step into that space more frequently. And I think for both parties, again, to bring it back to the deal, I think that that's something important to consider at the outset of any agreement. And especially for credit unions, it's like we said, you fully have every right to be excited about the prospects of what these products and services can offer, but you also do have to remember, and I would stress that you have to have the right frameworks internally to manage and mitigate risks that could occur, because as you had mentioned, as of right now, right, the credit union will most likely be on the hook in the event anything goes wrong with the model itself.
I think, Michael, I'd like to maybe just shift gears and talk about how do different sized credit unions get AI right? And I think there's a tendency for all firms, but particularly small credit unions, to kind of just see what's happening with the bigger players and how what they're doing, and perhaps copy the model that they take on. And I'm curious what the cost of that is, right? And what does a sized appropriate AI adoption actually look like?
Right. Yeah, it's an interesting concept, right? I think that smaller credit unions know, that they're at a disadvantage. Like AI is the latest and greatest technology and product servicing offering, but this is something that they've seen throughout their existence, right? And having the appropriate resources to acquire, gain access to these types of products and services. And then not only just with smaller credit unions, but I think credit unions themselves also feel this way in the financial space, right? Because they'll compare themselves to the larger regional or national banks too, right? But what I would say, to kind of get back to your question, and I think this is difficult to do, so I'm not trying to insinuate that this is easy by any stretch of the imagination, but I think it is important to shut out the noise, and the hype, and to really realistically get insight as to what you can either pay for or what you can afford to onboard from a technological side. Because again, at any time you have a regulator come into your shop, that risk will be measured as appropriate, given the size and complexity, of the product or service. So you have to have, again, I know I sound like I'm beating the dead horse here, but you really do have to have those internal frameworks in place to justify the risk that you may take as a smaller institution. But in addition to that, I would say for smaller institutions, they really have to figure out how to best maximize, right? What relative small resources they may have. So again, for our firm, we definitely use the CUSO model as a means to bring on multiple credit unions, whether that's through ownership or to service credit unions. So then this way, the CUSO now represents a network of credit unions that, they may have been small credit unions individually, but now they're represented by a larger force through a CUSO. I think you can also, if you're a smaller institution, really leverage these third-party relationships that we've been discussing, especially with regards to automation, whether that's through software or tools. The one thing that I keep, the yin and yang of this though, is I think that, with that, all these processes, whether it's the CUSO or it's through a third party, it still has to fit within what your vendor risk management framework is.
On your side, how are you seeing the legal profession shift or change, right? I think the general kind of maybe discourse is that lawyers now have better tooling, and so they could move more quickly in terms of how they could support clients. But at the same time, because of AI, perhaps there's also more work to be done. As you can see, like there's a lot more like regulatory uncertainty and potentially a lot more deal making and lots more risks that could surface when we're using agents and AI all over the board. And so in some ways, like the work itself has gotten more complex, but you have better tooling to potentially do the work. So I'm curious, what does it look like on your side, leveraging some of the tooling, the AI tooling that's available to you to help you get your work done better for your clients?
From the attorney perspective, tools have definitely become much more popular, and we see a lot of competition in this space, as to who can provide the best tool. And typically where you see it framed around is this for contract review or any sort of document review to kind of quickly summarize or to analyze a document and compare it to what you may have a standard playbook, for instance, and to see where there are discrepancies, kind of to suggest model clauses or, the way that you've kind of edited your own playbook and say like, oh, no, they're saying they're asking for 10%. We really need this to be 15%. So you can create tools to find and quickly address those issues. One of the things, that we've seen throughout the industry though, is I think, bad outputs, and hallucinations is still a very real issue. With regards to attorneys, we've seen attorneys that have relied for case law work, to find these cases, right, that have, it's become a disaster in some instances, when they bring these cases up into federal courts. So I think on the one hand, and you had mentioned and emphasized earlier, this importance of the human in the loop, right? So we do have these tools that make work, I think it's like the more like the boring task that we have to do, right? To identify these issues quickly, to give suggested revisions. I think that there's definitely those issues quicker. But, the issue really comes down to, are you actually going through and seeing what the recommendations might be? Because it might be something that you wouldn't recommend yourself. And certainly from a case law perspective, when cases that are completely fabricated are used as a means to justify your argument, that can destroy your argument essentially in your client representation.
Yeah, I think that's right. And that's why I think you see this in law and finance, and the parallels are similar, which is the impact of getting something wrong is pretty dramatic, right? And so you have to kind of take that into consideration. And in many ways, I think like for the most important deals and decisions, for better or worse, I think lawyers end up being a shield, right? Like they were hired to go and basically cover the basis of a deal, and so things aren't done well, like there's someone to point to for better or worse. It's no different than just like being able to, it's human nature, right? Like you need someone to have ownership and responsibility and accountability, and that's what lawyers take on, and so that's part of the job. And so yeah, I mean, I think that there are real risks to just kind of doing it yourself, a DIY approach, right? Sometimes you do need the professionals in. I think that's a really good response around how to do that well. And the risk of making mistakes and the impact of having those could be quite dire, right?
Yeah, and we continue to make it easy for people to come up with good lawyer jokes too, so that we have to at least keep that going as well.
That's right. Well, maybe to close this out, I'm curious, what does a credit union look like that gets this right over the next 2 to 3 years?
I think it starts and stops really with this robust and resilient risk management framework, and one that doesn't necessarily carve out AI services in particular, but addresses the unique issues that they present, right? And that's, I think, really along employee training, some of the detection stuff that we had discussed. So to kind of run in parallel to that, I think that a successful credit union that gets this right in the next few years will really value the importance of expertise in this area, to be able to explain how models work, how decisions are made from the model, and kind of like what I was insinuating just now is how to detect issues with outputs and how to escalate and remediate them on a timely basis. That's going to be really essential. And I think that the credit unions that have that personnel internally or that they rely on externally are going to be ahead of their competitors. And then we were also talking about changes too, right? This is a rapidly changing area. So I think awareness of those industry changes at the federal level, at the state level, whether that comes through laws or supervisory letters or guidance. And then one of the things too that I think is also really important right now is the court. The courts are given rulings with regards to AI products and services I think are really important to pay attention to, not just for the products and services themselves, but also the ancillary impact they may have, like around privacy or disclosure or just overall transparency itself. So I think if you focus on those three areas, and it is a lot, but I think if you get those areas right, I think that you're going to come out of this ahead.
Really appreciate all the insights, Michael. I think this is a really critical juncture for credit unions and CUSOs and fintechs to kind of navigate through. And just like the words of wisdom that you have here, I think are really critical. And it will be interesting to see how this plays out in the next couple of years as regulation changes or comes online for the first time. So I think I'm glad that we're bringing this type of conversation in, because I will say, like on our side as an AI startup serving credit unions and other financial institutions, we spend a lot of time going back and forth negotiating exactly these types of deal points, and it varies deal to deal, and part of it is trying to find a as you said, a framework, a good approach for what do you push on, what do you not push on, what's important to you, what are easy gives for you given the things that the other party really cares for, and I think you've helped articulate sort of how to balance that all. So appreciate the conversation and appreciate all the insights.
Yeah, no problem. Ankur, thanks for having me. I really thought that this was a very good discussion as well.